Hello everyone, I welcome you back to this series of legal reasoning, basic to advanced. Connecting it to the last lecture or connecting it to the last video of the course, I'm pretty sure that the principle or the idea that you do not require a prior legal knowledge, or the idea that the knowledge of law that is required to solve these questions or ace this section is really minimal. Anybody who is reader, a reader who has a good interest in law or has been reading news related to law knows the basics can ace these sections. Continuing the series, in today's lecture, we'll be moving ahead with the passages of the legal reasoning from the paper of 2020. So let's dive into the questions and see how we can solve them. On 7th May 2020, a major leakage of styrene gas was reported from the plastics manufacturing plant LG Polymers, located on the outskirts of the Visakhapatnam city. The accident took place when the cooling system of a polymer plant got clogged due to the mismanagement of factory workers and resulted in turning the city into a gas chamber. The gas which leaked was styrene gas, which is a hazardous chemical under Rule 2 Clause E plus Entry 583 of Schedule 1 of the Manufacture, Storage and Import of Hazardous Chemical Rules 1989. Talking about what we have gained from Para 1, we have just understood what the passage is going to be about. We are going to talk about plants, chemicals, and storage and manufacturing of such hazardous chemicals. We might also talk about loss that these chemicals cause. Let's move ahead into the lecture. Principle 1, Polluter Pays Principle. The doctrine of polluter pays is a well-established principle of environmental law, which places an obligation of compensating the damage to the people who ought to reimburse it, and also have the capacity to disburse it. From the first sentence, the basic idea is that the doctrine, which is named the doctrine of polluter pays, is a principle of environmental law which places an obligation of compensation of damage to the people who ought to reimburse it and also have the capacity to disburse it. The principle explicitly affirms that the person who damages or destructs the environment has the absolute obligation to bear the costs of ameliorating the environment. Fair. So anyone who damages or destroys the environment has the obligation or has the duty to repair it, and if not repair it, bear the costs of repairing it. In Enviro-Legal Action versus Union of India, the Apex Court of India held that polluter is legally responsible to reimburse the individual sufferers as well as pay for the revitalization of the damaged environment. Now, in this entire passage, something that is of high importance or something that will help us solve our questions is the last sentence. The last sentence provides us with a principle that can be applied to situations. It provides us a structure through which we can solve any of the problems that are provided to us. Principle 2, which is the principle of strict liability. The principle of strict liability was established in the year 1868 in the case of Rylance versus Fletcher, where the court held that any person who uses his or her land in an unnatural manner and who keeps any hazardous substance on such premise would be held liable under the principle of strict liability for any damage occurred on the escape of such perilous substance. However, the person is liable only when there is non-natural use of land. The principle also restricts liability when the escape is due to an act of strangers, act of God, for example, a natural calamity due to the person injured, or when it happens with the consent of the person injured or with statutory authority. This particular paragraph has given us a lot to think about, or rather, a lot to take down. First of all, if we go on to look at the components that would form principle, we can consider it a form of test that we need to apply to situations. First of all, the use of land must be unnatural. In sense, there must be hazardous substances present on the land. Fair? So first of all, there is a land, there are hazardous substances, and then these substances escape and cause damage. Now, most of us would think that this is enough for us to solve the questions. But then again, the later part of this particular paragraph goes on to state that the person is only liable when there is non-natural use of land. The principle also restricts liability. So basically, here we have been provided with an exception that applies to this entire scenario. Principle also restricts liability when the escape is due to the act of a stranger, act of God. So, we have been provided with an exception when such a hazardous substance escapes the premise where it was kept in, and the reason of such escape is not the owner, rather the escape is caused due to an act of stranger or act of God, for example a natural calamity due to the person injured when it happened with the consent of the person injured or with statutory authority. So here we have been provided with two more exceptions, one of which is consent and the other one is statutory authority. So in this paragraph, we discussed about the idea of strict liability. Not only this, but we also discussed about how strict liability functions. There needs to be a land. There needs to be unnatural use of land. In terms, there needs to be a hazardous substance or something that, if escapes, will cause damage. We also learned about exceptions like those of an act of stranger, act of God, consent, or statutory authority. Coming to the last part of the paragraph, the passage, principle of absolute liability. Till now, we have discussed what is polluter pays. We have discussed what is the idea of strict liability, and now we'll discuss what is the idea of absolute liability. Absolute liability is a stringent form of strict liability, as it is devoid of any exceptions that were mentioned under the earlier principle. For the first time, in the case of MC Mehta versus Union of India, this principle implies that whenever an enterprise is engaged in any dangerous or hazardous activity that threatens the people working in the enterprise and those living nearby, it owes an absolute and non-delegable duty to the community that no harm will be caused. If harm is indeed caused, the enterprise will have to compensate for the damages and can't use exceptions provided in the case of strict liability. The enterprise can't claim that the harm has been not caused due to negligence or absence of due care, or that it had taken all the reasonable precautions. The principle of absolute liability is, though parallel to the idea of strict liability, but is more stringent, as the passage says. It is devoid of exceptions and follows the same path, that there is an enterprise or there is a land which is then engaged into a dangerous or hazardous activity that threatens the working of people nearby, and if there is harm caused by such an activity or such a, what we would like to call, enterprise or such use of land, then there will be no exception or there will be no solution available to such enterprise or such individual that engages in all these acts. In this paragraph, we first talked about the idea of polluter pays, where anybody that is held liable for pollution or damage to the environment must pay to revitalize it. Then we had the principles of strict liability and the principles of absolute liability. The idea that remains consistent in both strict and absolute liability is that strict liability starts from a land, the unnatural use of land, and escape of a hazardous substance or an hazardous object that was used on the land, and the damage that it causes to the individuals around it. There are certain exceptions where we take into account the act of God, consent, statutory authority, or act of a stranger. The idea of absolute liability remains the same, works on the same principle, but rather there are no exceptions involved. Let's move on to the questions. Okay. Under which of the following principles will the company LG Polymers be liable? A. Polluter pays. As we have already read about LG Polymers caused harm to the environment. Fine. Strict liability. Fair. There was an unnatural use of land. The substance escaped and caused harm. Okay. Was there an act of God? No. Was it a statutory authority? We don't know. Was there consent involved? No. So, yes, it is liable for strict liability. And absolute liability, when we talk about, was there a hazardous activity being performed? Was it hazardous to people? Yes. They were storing styrene gas, which is a hazardous chemical according to the concerned law, as mentioned in the passage. So, option D becomes the correct one. As per the polluter pays principle, LG Polymers will be liable to pay A. Amount of money for restoration of environment only, amount of money for restoration of environment and compensation to the individuals who suffered loss, compensation to the victims, none of the above. Moving back to the principle, reimburse the individual sufferers as well as pay for the damaged environment. Now that we are clear, option B is the right option. Question 12 states that a company ABC Limited operates an industrial chemical plant in the city of Azadnagar. Due to an earthquake, the walls of the reactor in the plant get damaged, due to which the operators could not properly transport the hazardous gas for chemical vaporization, resulting in gas leakage. The gas leakage resulted in the death of 12 workers of the plant and some people living nearby. In the situation, decipher the liability of ABC Limited and choose the best option. The basic principle that we are to follow is there is a land, there is an unnatural use where hazardous substances are involved. Those substances escape and they cause harm. All these options or all these tests have been proved right. So let's see under what principles is ABC Limited liable. ABC Limited can be held liable under the principle of strict and absolute liability and the polluter pays principle as well. A lot of us would be attracted by this particular option owing to the fact that there was an unnatural substance or a hazardous substance that got leaked, and not only this, but it caused harm too. Considering the fact that strict liability provides us with exceptions, it provides us with some gateways. Let's see if those exceptions or solution can be used here. Going back to the principle of absolute liability and strict liability has an exception that relates to an act of God. In this particular question at hand, earthquake is an act of God. Not only this, but it was the reason, the earthquake was the reason that the hazardous gas leaked and caused damage. So we are certain about the fact that under the principles of strict liability, we cannot make ABC Limited liable. But when we talk about the principles of absolute liability and polluter pays, both these principles have no exceptions. So under both these principles, we can make this particular company, ABC Limited, liable. Looking at options C and D, ABC Limited will not be held liable. ABC Limited will be held liable under strict and absolute liability. We cannot go ahead with this option, neither with this. Yeah, we are left with option B. ABC Limited can be held liable under polluter pays and principle of absolute liability, but can be exempted from the liability under strict liability. Fair. That's what we were looking for. Let's move to the last two questions from this paragraph. The argument of LG Polymers that they did not know that the styrene gas could leak. Is it a strong argument or is it a weak argument? Let's see. The strongness or the weakness of an argument is judged upon how well it is substantiated. Now, LG Polymers stating that they were unaware of the fact that a gas could leak. Such an argument on the face of it has no reason to substantiate itself. Not only this, but this entire argument is based upon a simple excuse of not possessing enough knowledge, which cannot be considered a strong argument. So we'll negate option A and B and move to option C and D. So C says that it is a weak argument and will not help them reducing the liability of LG Polymers under any of the principles. Fair. Is a weak argument but may help in reducing their liability under strict liability principle. Strict liability only exempts you from being held liable when either it is an act of God or a third party, when there was consent, or when the entity in question is a statutory entity. Any of which is not present here, so we'll move forward. XYZ is a company operating a pesticide factory in the city of Rampur. One day, due to the negligence of factory staff, there is a leakage of pesticide gas. As a result, many pests and insects which feed on plantation crop in nearby farms are killed. Fair. There is no harm caused to the people. However, the leakage was so humongous, it reduced the quality of the air in the city and created breathing problems for the people living around.